All right. Good afternoon, Mr. Sorrells. How are you?
How about yourself, Your Honor?
Doing fine, doing great. All right, this is cause number CR 22-397, State versus Derek James Silva. Is Mr. Silva there in the courtroom with you?
Yes, Judge.
All right, everybody have him come on up. All right, Mr. Silva is set on a motion to revoke today, and I believe this is on a misdemeanor cause. Is that correct?
Yes, Judge, I believe it's a Class A.
Okay. Any announcement from the defense?
Judge, we're announcing not ready. We're asking to pass this for the sometime in the next 2 weeks here. I think we've reached an agreement and we just need to get it in front of the court.
Okay. I can set it on May 30th. Does that work for the state as well?
Yes, Your Honor.
Okay. Mr. Sorrells, will that work on your calendar?
It does, Judge. If there's a way to do it before that, I think that would be more time than the deal that we've agreed to. If it's possible to do it on the 17th or the 25th, and I understand if it's not, Your Honor.
Not the 17th, but the 25th, I do have a criminal docket, but I'll have a visiting judge here. And I was trying to keep that load pretty light for that visiting judge. Is there a overriding need that we need to have it done before?
Judge, just for the court's information, we reached a deal that was, if we could get it done today, would involve Mr. Silva spending about another 2 weeks in jail. So if we could set it for that, it's going to be basically at that time just a time served offer. So I don't anticipate it being overly onerous for a traveling judge to hear this case and resolve it on the 25th if the court's comfortable with that.
Okay. And is Mr. Silva, is he doing time? Is he doing probation on the revocation? What is he doing?
It will be time, Judge, and at that point he will be basically time served. It is a Class A misdemeanor, and I believe the agreement we have will basically, even if we got it done today, would likely have him serving till basically the 25th anyway. So that actually works out just fine, I believe, by the agreement that we've reached.
Okay. All right. Court will set Mr. Silva then for plea before the court on May 25th. Yeah, we'll just set it May 25th. I'm not sure if we had afternoon settings at all. I'll tell you what, give me just one moment. Let me consult with Ms. Abraham because we may not have a visiting judge, but only that morning. Stand by.
Judge, let me just ask, is the 25th the only docket we have between now and the 25th? Is there not one the 23rd? Or would that maybe not work? Because if Mr. Sorrells could go over the paperwork with his client, we could probably do that by Zoom if we could figure that out, because will be just a misdemeanor plea to basically time served, and balance of financial obligations is the agreement we've reached at that point. So I believe that we could be fairly flexible with the procedural matters on this, given what the court would be comfortable in, obviously Mr. Sorrells's calendar.
The only dates that I have are the 25th, which there will be a visiting judge here, and I would need to check to see if we could have him either brought over. If I don't know that I have a jail docket that day, or the 30th. I will be here on the 30th. I understand that they want it done before that. So if you're, I don't know what you're exactly what are you asking for, Mr. McClain? I guess I'm not clear.
I wasn't aware if there was an additional docket setting in between now and then. If there's not, that's fine. I'm not asking to set additional settings. I was just inquiring whether there was another. I haven't looked at my calendar between in the next couple of weeks for if there are any. So it sounds like the 25th is going to be the day if we can make it work. And then we'll have to figure something else out if that won't work.
Yeah. Give me just a second. Let me check to see if my visiting judge is going to be here morning only or morning and afternoon. Hang on just a second.
Yes, Judge.
Mr. Williams, can we just take a look at your packet?
All right, so what we'll do is we'll set it for Tuesday, May 25th for plea. Judge Griffith will be here that day, and we'll just ask that Mr. Silva be brought over to the courthouse at 9 a.m. and it'll be an in-person plea.
Thank you, Your Honor.
Thank you, Judge.
You're welcome. Do you have anything else, Mr. Swills?
I don't know, may I be excused?
Yes, thank you, sir.
Mr. Carter. Order me to-
Brett, how are you doing, sir?
How you doing?
I'm doing fine. Mr. Wood, how are you doing, sir?
Good, doing well. How are you?
Hey, I'm doing great. I'm doing great. How's Brett doing these days?
He's good. We've had some good conversations, me and Mr. Turnage, and I'm happy to report, Judge, I think we've been able to come up with a resolution on this case and we're ready to proceed this afternoon.
All right, great. All right. Brett, if you don't mind, will you raise your right hand, sir? I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. All right, I got some questions for you. Your name is Brett Lawrence Turnage, is that right? And Mr. Turnage, you are a United States citizen and you do know how to read, write, and speak English, is that right?
Yes.
And today you have filled out some paperwork regarding your criminal cases that are plea agreements. You talked about that with Mr. Wood, who's been your attorney for quite some time now. Do you understand everything that you've read and signed today?
Yes, sir.
And are you happy with Mr. Wood and the work that he's done for you as your lawyer?
I am, yes, sir.
All right, good. Is there anything about that paperwork that you've read over and signed today, Brett, that you don't understand?
No, I understand everything.
Okay. And Mr. Wood, we have had numerous hearings in this matter, and we've worked to get medications and hospitalization for Mr. Turnage. Today, you're telling me you believe that Mr. Turnage is competent and he's entering into these plea agreements intentionally, knowingly, and voluntarily. Is that correct?
That is great, Judge. I had a conversation with Mr. Turnage while he was actually at Rush State Hospital. That conversation was via Zoom and it was a good conversation. We had a good talk about the discovery in the case and what we're planning on doing with the case. And then again, this morning, I had another good conversation with Mr. Turnage. So at this point, Your Honor, I don't have any issues whatsoever with Mr. Turnage's competency.
Well, thank you. That means an awful lot to me because I think you would know better than most. You've had more communication and personal dealings with Mr. Turnage than anyone in this court or the DA's office. So I'm very comfortable if you're comfortable and confident that Mr. Turnage has reached that level of competency to where he can deal with this matter today. So with that, Brett, let me tell you, you've been charged with a third-degree felony offense of driving while intoxicated, third or more. That does have a penalty range of not less than 2 years in prison or more than 10 years in prison and a fine of not more than $10,000. I see that you have reached a plea agreement with the state that Mr. Wood has helped you on, and it looks like you would be pleading guilty to that crime. The state would recommend that your sentence be set today at 4 years in prison.
Judge, if I might interrupt, we have updated paperwork. I believe that was a typo on my part, telling Ms. Abney it's actually 3 years TDCJ. Mr. Wood, I believe, has updated paperwork. It just occurred to me as you started reciting the agreement that you may not have received the updated paperwork, but it is 3 years in the Texas Department of Criminal Justice, not 4 years.
Okay, and let me go ahead and verify the jail credit. 1,234 days, 1, 2, 3, 4. Is that correct?
That's my understanding. Yes, Judge.
Okay. All right. And so let me start over, Brett. I'm sorry. So it appears that the plea agreement is that you would plead guilty to that driving while intoxicated charge, the state would recommend that your sentence be set today at 3 years in prison. You would receive credit for 1,234 days toward that sentence by the time that you have spent in jail on this case. You would have a $100 fine. You would pay court costs, restitution, and reimbursement fees. Brett, is that your understanding of the plea agreement today?
Yes, sir.
All right, Mr. Wood, yours as well.
It's mine as well, Your Honor.
Okay. Understanding that, and then Brett, I have to ask you at this time, how do you plead to driving while intoxicated third or more? Are you guilty or not guilty?
Guilty.
All right, and court asked now, Brett, are you saying that you're guilty because you acknowledge that you're guilty of committing this offense? You're not doing it because someone's threatening you, forcing you, or making you do this. Is that right?
That's right.
All right, court will accept Mr. Turnage's plea of guilt. Mr. Wood, any objections to the state's evidence supporting the plea?
No objection.
All right, the court accepts the state's stipulation of evidence. The court takes judicial notice of Mr. Turnage's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close at this time.
Is there anything further from the defense?
Not from the defense, Your Honor, except for the fact that I believe the state is also going to dismiss the other two, I think, pending charges against Mr. Turnage, and I expect Mr. Woodwhite will accomplish that after this hearing.
Yes, Judge, that is a true. Mr. Turnage does currently have pending an injury to the elderly and a retaliation. We will be, upon the finalization of this plea, we'll be dismissing both of those at the complainant's request. She has requested for basically 3 years that those have been dropped, but we will be just dismissing those upon the finalization of this plea.
Okay, thank you, Mr. Floyd. All right, court's reviewing the evidence briefly. All right, court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Turnage of this offense. Court will follow the plea agreement in this case. The court hereby convicts Brett Lawrence Turnage of driving while intoxicated third or more. A third-degree felony, assesses his punishment pursuant to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice. Court awards Mr. Turnage 1,234 days credit towards that sentence for the time that he has spent in jail on this cause. Court orders him to pay a $100 fine, $60 restitution, $290 court costs, and $15 in reimbursement fees. And the court notes for the record the disposition of the other cases as read into the record by Mr. Wood and Mr. Woodwhite. Mr. Turnage, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. In just a moment, I'm going to have you step over and be fingerprinted with Deputy McLeish. But first, I want to ask you the medications that you're on. Are they're making you feel better, correct?
Yes, sir.
So you understand everything that's going on. You've already answered that. I just want to say we've been doing this for a number of years now. Me, you, and Mr. Wood, and you look a lot better. And I'm glad to see you.
Thank you.
I feel like I'm talking to Brett Turnage now for the first time. So it's like meeting somebody that I've known for a long time, but I'm really just getting to know them. So I want to say I'm glad that you went through that process and that you're at the position that you're at now. And I hope you're able to maintain where you're at. Okay.
Thank you.
You're very welcome. You'll step over there with Deputy McLeish. She's going to take your fingerprint and they'll give you the next steps. Okay.
Judge, I think that's all I have this afternoon. I'm going to be excused.
Mr. Wood, this doesn't conclude your business in Van Zandt County once and for all, does it?
No, absolutely not. I love this place too much.
Before you submit your final bill, I want you to talk with Ms. Abraham, okay?
You wouldn't what, Judge? I'm sorry, I missed that.
Before you submit your motion to pay on this plea, I want you to talk with Ms. Abraham.
Okay, all right.
All right, thanks, sir.
Good to see y'all.
Good to see you.
Mr. Professor, you ready to go? All right.
All right, good afternoon, sir. All right, let me flip over here to your case. All right. This is Mr. Wheeler, correct? You're Jake Wheeler? Okay. All right, this is cause number CR 23-22, State versus Jake Wheeler, and we're set for pretrial today, Mr. Bass.
I'm not sure what the setting was. I just got the information that it was set today, so I'm here for it.
Yes, it's set for pretrial, so I would be looking to know if you filed any contested pretrial motions that will need hearings, motions to quash, motions to dismiss, motions to suppress. Are you going to need an evidentiary hearing on any of those matters? And then I'd want to know, have you received the discovery? Are you missing anything?
Judge, I've got the offense report. It looks like, and looking at this again this morning, there's some video of the dash cam. There may be security surveillance video that, and we may have a link for it, but I haven't seen it yet. And it may be our fault, but anyway, I haven't seen that yet. But
Judge,
I may file a motion on it.
Judge, if I might, just looking in our system, it appears as though Mr. Schmidt, who is Mr. Wheeler's court-appointed attorney, picked up discovery basically 10 days ago. It appears as though we were unaware that Mr. Bass was substituting in for that. So it does not appear as though Mr. Bass has that. We will need to make arrangements to get those to him. I will submit to the court. We have not turned over to his current attorney. We turned it over to his previous attorney. Maybe, I'm not sure when Mr. Bass was actually retained on this case. So we would be unopposed to an additional pretrial setting so we can make sure that Mr. Bass has all the discovery, and then we can communicate further as to resolving this case, going to trial, whatever it is that we need to do on it.
Thank you. That'd be fine.
Yeah, and so Mr. Bass was substituted in back in April. I was looking at certificate of service. It says Mr. Bass served that on the Harris County Criminal District Attorney's Office. So I don't know if he got e-filed to the wrong DA's office or not, but nevertheless, it was granted by the court back in April. So court will reset Mr. Wheeler today for pretrial hearing. And Mr. Bass, if you have your calendar available, I'm going to give you some dates, and I want you to tell me.
I do. However far the court wants to go out with it, I got my calendar right here.
Okay, I'm going to give you some dates. I want you to tell me which one you prefer. June 13th, 15th, or 27th.
27 sounds good, Judge. 27.
All right, that's going to be set at 1:30 in the afternoon. All of jail cases are called in the afternoon. If Mr. Wheeler ever makes bail, that's going to move his court time until 9 a.m. That'll be in the courthouse. So, all right, court setting Mr. Wheeler then for an additional pretrial on June 27th at 1:30.
Great. Thanks very much.
You're very welcome.
And Mr. Bass, we'll get that white copy for you, so I hope that. You're fine. Your Honor, we have Mr. Manning working feverishly. However, he is still working. Can he have just a few more minutes, please?
Anything from Mr. Manning?
Okay, thank you, sir. Oh, Your Honor.
To that, Judge.
What is the reset date for Mr. Bass again, please?
June 27th
Very
at
good.
1:30.
Yes, sir. Thank you, sir.
You're welcome.
No, I forgot. They didn't want you to book it. We'll check on it. We'd like to take it back to the jail and. That's kind of the regular view. Okay, that's fine.
Your girls.
My oldest is 21. And 14.
Full already, huh?
Yeah.
And the second one is home.
She'll be 15 in 4 weeks.
Cool.
Yeah.
What's she doing?
She has a lot of cheer competitive.
Oh, okay. That's a fine.
I feel like they have to do something.
They do. They really do. They have to be part of something in the team. Mine is. Go a lot. If you think about two things, I do. Yes, yeah, everything's a fine. You want something to eat, why? Oh. But if I even think about if she's ordering and I should happen to have a pain or something because what she ordered. You know, okay, that's too bad.
I'm already here. Are you ready?
All right.
Well, this one.
All right. We are not, this will be Harris. We can bring this and see you step up to the podium. You ready to take care of you, Mr. Manning?
Good. Son.
And then you'll need some more downtime with your other spread. Okay. Let me try to help you. I know you're going to simply are all their other spread resets.
Miss Blair and Mr. Rudd are gonna be the other pages. And then we'll need to reset.
No, I'll do your resets for you. How's that?
Excellent.
Mr. Manning, if you'll give Judge just a few minutes, he stepped out of the courtroom.
No problem. There we go. I didn't get to go back to my office. She controls the better than I do. Yes. I'm gonna sit around and make you go. No, sorry. Thank you. English do that.
I know.
Oh, you don't need to do all that. You can leave that blank. I'll just throw my signature on together. You can just get this, this. That'd be great. Hit that, I'll sign here, defendant will sign there. Judge will give us the state. Okay, cool. Yeah. I appreciate it.
No problem.
Well, yeah, it's just one, yeah, all, yeah. It's like that. Oh, yeah, we didn't answer his question on that. Yeah, it is.
Mr. Manning, who are we ready on?
Good, ready, Mr. Smith.
All right, this is cause numbers CR 22-285, 286, 287, 288. 289, 290, 291, 292, State versus Clarence William Smith. We're set for plea today, is that correct, Mr. Manning?
That's correct, Judge.
All right, can you tell me the terms of the plea agreement on each specific cause number?
Yes, Judge, starting at 285, a straight motion to dismiss. 286, 287, and 288 will be 1245 agreements. And then the remaining cause numbers 289, 290, 291, and 292 will be consecutive pleas for TDC.
Okay.
Reject the terms, Judge.
Yes, please.
In those consecutive pleas, upon a plea of guilty, state agrees to recommend that punishment be assessed at 10 years, TDCJ, institutional division, a fine of $500. They agree to 1245, CR 22, 286, 287, 288. And that time is run consecutively, as I said, with 290, 291, and 292. The fine, as I said, was $500, court cost $290. There's a $20 reimbursement fee. Additionally, he has 421 days credit on each of those charges. Additionally, Judge, just for record purposes, he was arrested on nine additional offenses. And as my understanding, the state has rejected all of those. I received rejections for some of those, but I don't know if I have in my file rejections for each and every one of those cases. So just on the record that is our understanding and agreement that the remainder of those cases are rejected.
Okay. And so just a point of clarification. So you said that these last four cause numbers, 89 through 92, that they are to run consecutive with one another. Is that correct?
That is correct, Judge.
Okay. All right, Mr. Smith, if you'll raise your right hand, I'm going to place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, lower your hand. Your name is Clarence William Smith, is that correct?
Yes, sir.
And Mr. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented, in all these cases, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case, that you've had all of your legal questions answered?
Yes, sir.
Is there anything about any of these plea agreements that you signed and read through today with Mr. Manning that you don't understand?
No.
Mr. Manning, do you believe Mr. Smith to be competent today? And if so, have you explained to him his rights as they pertain to these plea agreements? And if so, do you believe that he is entering into each intentionally, knowingly, and voluntarily?
And Judge, in response to his competency, he is competent in response to his ability to understand what's going on. I believe he does. He's asked questions, and I've explained to him the ramifications of the charges that he is pleading guilty to, as well as the consequences of those pleas. We've discussed his registration requirements, as well as the parole consequences of pleading consecutively. And I've advised him on all those things and answered his legal questions. So I believe he is taking this freely and voluntarily.
Thank you, Mr. Manning. All right, Mr. Smith, in cause numbers CR 22-289, 290, 291, 292, you are charged by indictment with a third-degree felony offense of possession of child pornography that does carry a range of punishment of not less than 2 years or more than 10 years in prison, and carries a fine of not more than $10,000 if imposed in each case. The court, having heard the plea agreement in this case, finds that the proposed sentence does lawfully fit within the range of punishment allowable by law. And so at this time, understanding the plea agreement, understanding the range of punishment, Mr. Smith, how do you plead to possession of child pornography in each of those 4 cases?
Guilty.
Are you pleading guilty to each of these crimes because you are guilty of committing those crimes, and you're not just saying that to get a certain plea agreement?
Yes, sir.
All right, the court, well, let me ask you, Mr. Smith, have you ever been pressured, forced, or made to feel like you had to plead guilty to any charge?
No, sir.
All right, court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the state's evidence supporting the plea?
No objection to the state's evidence supporting the plea. I would ask, and I don't know if the state's already asked, that those exhibits be sealed, as they do contain sensitive victim information. But no objection to states one in each cause as they are presented.
All right, then states 1, stipulation of evidence in each cause is admitted into evidence. The court takes judicial notice of each of Mr. Smith's judicial confessions. Is there anything further from the state at this time?
Yes, Your Honor. In regard to victim notification, I've spoken with the mother of the child, and she is supportive of this plea today.
Thank you, Ms. Heisel. Anything further from the defense?
Nothing from defense.
Ms. Heisel, can you give me the evidence to support the plea?
Yes, Your Honor. Mr. Smith is the stepfather of the child in question. She was 14 at the time. In March of last year, the mother was going through Mr. Smith, who is the mother's husband's phone, and found some photos of her daughter and other children on that phone. That led to a family member making a report to law enforcement, which yielded a search warrant and subsequent search download of that phone, which revealed a number of images. Specifically, the 4 that Mr. Smith is pleading to today are images of that stepdaughter that show her fully nude in 3 of the 4 photos, and in the 4th photo shows her engaged in sexual conduct with what appears to be an adult male.
All right, thank you, Ms. Heisel. Mr. Manning, any objections or modifications to that summary?
Judge, I believe that accurately reflects the evidence as we understand it.
All right. Based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Smith of this offense. Court will follow the plea agreement reached between the state and the defense. Court, pursuant to the plea agreement in cause number CR 22-289, 290, 291, and 292. Court convicts Mr. Smith of the possession of child pornography, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $500 fine, $290 court cost, $20 in reimbursement fees. Court awards Mr. Smith 421 days credit towards his sentence for the time that he has spent in jail on each one of these causes. And the court will order each sentence to run consecutive to the other causes. Furthermore, the court dismisses under section 1245 in pursuant to the plea agreement, cause numbers CR 22-285, 286, 287, and 288. Mr. Smith, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Have you step over with Deputy McLeish to be fingerprinted.
And Judge, just one slight correction, 285 was not part of the 1245, that was a straight dismissal. Additionally, we would request an order sealing that states Exhibit A.
All right, the court will correct the record. The court will dismiss, not under section 1245, but on the state's motion to dismiss, cause number CR 22-285. And the court will order that state's evidence be sealed. I believe it's already sealed, but as further protection, the court will order that to be sealed.
Thank you, Judge.
Everybody, and it actually is in there now.
She is came out and she's out.
Okay.
Need more time, Mr. Manning, or are you ready?
Judge, we don't have anybody else here at this point. I'll have two other pleas I need to go over with my clients. We were working on some jail time credit up until court this afternoon. So if you'd like to, I can text when we're ready, or if you want to do some quick resets, once they bring those in, we can do those as well.
You have the individuals in the courtroom that'll be reset.
No, they're still bringing them.
Yeah, that's fine. Just go ahead and work through your pleas, and then we'll just take them all at one time.
Yes, Judge.
Thanks, sir.
You what? Yes. This ain't all bad, but it's easy to acknowledge you're here, right? It depends on who you're asking. Yes. What I do is to always please and change information. Share your information. Oh, yeah, that's what happens.
Mr. Manning, I'm ready when you are.
Sorry, Judge.
All right, remind me who you have.
This is Mr. Larry Rudd.
All right, Mr. Rudd, this is file number CR 21369. Mr. Rudd, where you're at, just raise your right hand. I'm sorry, this might be better. I want to place you under oath at this time, Mr. Rudd. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Just make sure you speak up loudly and clearly for me. Mr. Rudd, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any kind of mental condition?
Yes.
Can you tell me about that?
Oh,
I'm sorry, Mr. Manning, I couldn't hear what you said.
Judge, he has a heart condition. He's had 2 heart attacks while he's been in custody. I think he misunderstood your question, but to my knowledge, he does not have any mental health diagnosis.
Okay. All right. And Mr. Rudd, you are represented by Mr. Manning as your attorney. Are you pleased with the work that he's done for you?
yes.
Do you feel like you've had enough time to talk to him about the case, that you've had all of your legal questions answered? And is there anything that you don't understand about the paperwork today that you've read and signed?
Oh,
Mr. Manning, do you believe Mr. Rudd to be competent?
I do, Judge.
You explained to him his rights as they pertain to this case and the consequences of the plea.
I have.
You believe he's entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Rudd, you are charged by indictment with a 3rd-degree felony offense of driving while intoxicated, 3rd or more, that carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. Also, I believe that the state has enhanced has the state enhanced the range of punishment in this case, Mr. Manning?
Yes. Judge, on behalf of the state, yes, the state, there were I believe in the indictment, there were 2 enhancement paragraphs. State is going to be abandoning the 2nd enhancement paragraph. So we believe that the proper punishment range for this would be that of a 2nd-degree felony of 2 to 20 years to a $10,000 fine.
Okay, then I'm gonna need a new front page of the judgment because the one that I have says 3rd degree. Is that what you have, Mr. Manning?
That is correct, Judge. And I was going to point that out. It's conflicting that it says 3rd degree, but it also has them pleading true to the enhancement paragraph.
Just for my clarification, it still remains a 3rd-degree felony, just punished as a 2nd degree within the 2nd-degree range. However, the court would feel we can correct that. I just want to make sure that we're all saying the same thing. DWI with 3rd or more is a 3rd degree, and then the enhancement paragraph would make it a 2nd degree. Would the court prefer that it say 2nd-degree felony? Because we can easily do that. I just want to make sure that that's what everyone wants.
I believe that the judgment would have to say that the degree of the offense is elevated to that of a second degree.
Okay, Judge, we will definitely refer, we will send a copy of it, the judgment that says second degree felony right below where it says DWI third or more.
And Mr. Manning, your client is going to be pleading true to enhancement paragraph 1, is that correct?
That is correct, Judge.
All right, and so Mr. Rudd, the state having indicted you with the offense of driving while intoxicated third or more, that is a third degree felony offense that carries a range of punishment from the minimum 2 to a maximum 10 years in prison. And the state has also alleged an enhancement paragraph based on your criminal history with a prior conviction from 1986 in Dallas County. That enhancement, if found true, would elevate the range of punishment for a third degree felony offense to a second degree felony offense. And that does change the range of punishment. The range of punishment is changed from 2 to 10 to 2 to 20 years in prison and a fine not to exceed $10,000. I see that the plea agreement in your case is that you would plead guilty to that offense. You would be true to the enhancement paragraph. The state would be recommending that your sentence be set at 10 years confinement in prison with a $100 fine plus court costs and reimbursement fees. You would receive credit towards your sentence for 103 days. Mr. Rudd, is that your understanding of the plea agreement?
Yes.
All right. And Mr. Manning, yours as well?
That is our understanding, Judge.
Okay. So, Mr. Rudd, let me ask you, how do you plead to driving while intoxicated, third or more? Are you pleading guilty to that crime because you are guilty of that crime and for no other reason? Okay. And has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right. And Mr. Rudd, I also have to ask you, with regards to the enhancement paragraph alleged in the indictment, wherein the state has alleged that you were previously convicted on March 6th of 1986 in Dallas County for the felony offense of aggravated kidnapping. Is that allegation true or not true? Did he say true, Mr. Manning? I couldn't hear you.
Not true.
Not sure. Judge, I think the confusion is that he is still protesting his innocence on that charge, but he was found guilty of that charge in paragraph 1 in March 6th of 1986.
All right. So, Mr. Rudd, you do plead true to the fact that you were convicted. I understand that you're denying guilt, but you do plead true that you were convicted on March 6, 1986 in Dallas County of the offense of felony aggravated kidnapping. Is that true?
Yes.
Okay. All right. And Mr. Rudd, has anyone forced you to plead true to that offense?
No.
All right. The court accepts the defendant's plea of guilt and his plea of truth. Mr. Manning, any objection to the evidence supporting the plea?
No, Judge. We reviewed the evidence supporting the plea. We've had an opportunity to discuss potential defenses, and that is an accurate representation of what was gathered by the state trooper.
All right, then the court admits State's Exhibit 1, the stipulation of evidence, and takes judicial notice of the defendant's judicial confessions. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Rest and close, Judge.
All right, Mr. Woodwhite, actually, I'm going to review the evidence briefly.
Yes, Your Honor.
All right, court has reviewed the evidence, finds that there is sufficient evidence to convict the defendant. The court follows the plea agreement in this case. The court convicts Larry Rudd of driving while intoxicated, a third or more offense. The court finds the enhancement paragraph number 1 in the indictment to be true. The court finds that the third degree felony is increased to a second degree felony. And the court imposes sentence pursuant to the plea agreement at 10 years confinement. The Texas Department of Criminal Justice Institution Division orders him to pay a $100 fine, $290 in court costs, $140 in reimbursement fees. And the court awards Mr. Rudd 103 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Rudd, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I need you to go over with Deputy McLeish. She's going to take your finger.
Judge, just for the court's information, I have sent to Ms. Tabraham and Mr. Manning a corrected front page that reflects second degree felony on the face of the judgment.
Thank you, Mr. Woodward. I do appreciate it. All right, who's next?
Judge, Mr. Ronnie Cotton.
All right, Mr. Cotton, if you'll come forward.
You have to sit down. Here you go.
All right, Mr. Cotton, if you'll raise your right hand, place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
All right, you go. All right, Mr. Cotton, a couple of issues before the court. I believe one, the state and defense have reached an agreement with regarding bail. Is that correct?
Correct.
All right, and the court finds that Mr. Cotton's bill should be reduced. The court's going to approve the agreement of the state and defense. Also, Mr. Cotton, I see here that you want to execute a waiver of jury trial. Is that correct?
Correct.
And this waiver of jury trial tells me that you've spoken with Mr. Manning, your attorney, and that you understand that you have the right to have your case tried before a jury of your peers, but that you can waive that right as long as you're doing that intentionally, knowingly, and voluntarily. And you also understand that if the court approves your waiver of jury trial, that case may not be restored and given back to you. You understand that, correct?
Correct.
If you give up your right to a jury trial, then you also give up the right to cross-examine the state's witnesses, confront their witnesses and their evidence in front of a jury. You understand that?
Correct.
And Mr. Cotton, most important of all, you understand that no one can take away your right to a jury trial. You understand that?
Correct.
You and only you have a decision whether you waive that today. And that's what you're asking the court to do, is to allow you to waive that right. Is that correct?
Correct.
Mr. Cotton, has anybody threatened you, forced you, or made you waive your right to a jury trial today?
No, sir.
All right, court will find that Mr. Cotton has been admonished with regards to the rights of his jury trial and the waiver thereof. Mr. Manning, do you join Mr. Cotton in the waiver of his jury trial?
I do, Judge. We have a written waiver of jury trial that I have signed, my client signed, the state signed, and I will send that back with paperwork.
All right, Mr. Woodwike, on behalf of the state, I find you are also waiving the state's right to a jury trial.
That's correct, John.
All right, court having found that Mr. Cotton has waived the right of his jury trial in open court, finds that he has done so intentionally, knowingly, and voluntarily. After admonishments by the court hereby approves the waiver of jury trial. And let's see, Mr. Cotton, we need to set you for your next hearing. Mr. Manning, I believe we're also set on pre-trial today. Are there any contested pre-trial issues or just pre-trial issues the court needs to be aware of?
Judge, we do have some contested pre-trial issues that we're still developing. I've spoken to Mr. Cotton about some of those issues. However, due to the need to get him out on a PR bond for his medical situation, we will request that be reset so we can get that squared away, and then we can discuss his options on pre-trial.
Need to set this out further than 30 days.
Yes, please, Judge.
All right, let's see. Did we set one of your clients earlier today in July? Mr.
No, I believe we had to bump that to August due to my vacation letter and jury selection in Kaufman County. I believe we selected August 10th.
All right, we'll set Mr. Cotton for pretrial hearing on August 10th. That will be at 9 a.m. so long as Mr. Cotton is on his personal bond. It'll be at 1:30 if he's not on his personal bond. Mr. Cotton, I recall the last time you were on bail, you didn't comply with your conditions. So I'm expecting a different result this time. And so if you're going to be out on bail, I expect you to comply with all of your conditions. And the purposes that you're being let out for, I need you to take care of those. You understand what I'm telling you?
Yes, sir.
All right, so if I find that you're testing positive or you're doing things that you shouldn't be doing, medical or no medical, you're coming right back in jail. Understand?
Yes, sir.
All right, sign your notice right there. And Mr. Manny, have you submitted motion for or agreed order on PR?
I have not yet, Judge. I did not have an opportunity after lunch to do that, but I will have one by the end of the day today, Judge.
Okay, as soon as I see that, I'll get that signed for Mr. Cotton.
Thank you, Judge.
You're welcome. All right, who's next, Mr. Manny?
We have Michael Davis.
Michael Edward Davis, CR 22-176 for pretrial. Go ahead, Mr. Manny.
Judge, Mr. Davis, prior to some incidents in the recent past, was on bond. He was rearrested, and so I requested we set a pretrial out for one more time to make sure that there's no other charges going forward. I've received what I believe to be the state's best offer, but I would like to continue negotiating once we get a final disposition on those other outstanding issues.
Are they new charges that you expect to be indicted or filed?
My understanding from my last talk to the state this week was that there was not an expectation that those were going to be filed. However, they had not received final disposition on those yet. So I would just like to confirm that before we proceed.
Yeah, I understand you're asking for a pretrial, but there's no pretrial issues in this case, correct? There may be issues in the other cases, but there's no pretrial in this case.
That is correct, Judge. Not that I've seen or discussed with my client at this point in time.
So I think what I'd rather do is set it for docket calls, and if those other cases get filed, then we'll delay a final docket call announcement.
Yes, Judge.
Okay. All right, court will set Mr. Davis then for docket call on June 15th. All right, Mr. Manning, anyone else? It's Mr. Ozuna.
Yes, Judge.
This is cause number CR 22-385 and CR 22-282. State versus Richard Ozuna Jr. for pretrial. Go ahead, Mr. Manning.
Yes, Judge. As you know, this case has been pending for quite some time, waiting the production of evidence in Mr. Ozuna's case I can let you know that the state produced a copy of what was supposed to be on the DVR. I went to their office to review after the last court date, and it was missing the date in question. So I have since had my expert go pick that DVR up. He updated me as of today that is still in the works. They're still diagnosing and analyzing that. And so we request a reset for an additional pretrial. I don't believe it needs to be very long, as it is in his possession and he is working on it.
All right, court will reset Mr. Ozuna for additional pretrial on June 15th. Who's next?
Judge, William DeCappa was just appointed to me. If we could have him called up.
All right. Mr. DeCapria, CR 17283, motion to revoke. All right, court will set Mr. DeCapria. Do you want him? I can set him on the contested docket on this month, May 30th, or we can set June 29th.
Judge, actually, he has a new case that we're here on arraignment for as well. I'd ask him to keep those together.
All right, well, let's do this then. Let's set Mr. DeCapria then for pretrial in CR 20113. We'll conduct the arraignment in just a moment. We'll do June 15th on each one of those. And on, let's see. Then on June 15th, we'll talk about if we need a contested hearing on the MTR. Mr. DeCapria, if you'll raise your right hand. Actually, I don't. Mr. Meany, are you ready on arraignment? You can put your hand down. I'm sorry, sir.
Yes, Judge. His name is spelled correctly. He understands the charge against him. The range of punishment. This time we're pleading not guilty and request to be set on the pretrial docket.
All right, court will enter Mr. DeCapria's plea of not guilty into the record on the charge of possession of a controlled substance, penalty group 1, less than 1 gram, state jail felony, and CR 20113. And sets pretrial June 15th. Sets the motion to revoke June 15th as well.
And Judge, there was one other issue I emailed the court coordinator about, as well as the state. Came to my attention as I was reviewing and getting ready for court on Mr. DeCappa's case that I was previously involved in his case in making the offer on his original probation case as a prosecutor. I've spoken to him about that and asked him if he would like to assert his right to a conflict. And he said he would like to waive that. So if I can just call him briefly to testify to that.
So this time I will have you raise your right hand. I will place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Just make sure you speak up loudly and clearly. I know you're standing right next to Mr. Manning, but I need to hear you and my court reporter needs to hear you. Okay, go ahead, Mr. Manning.
Mr. DeCappa, we met in the jail last Friday. Is that correct?
Yes.
And we discussed your case. We began developing some potential resolutions for your case. But when I spoke to the DA's office this past week, I learned that I was representing the state of Texas when you were put on probation in CR 17283. Is that correct? Is that your understanding?
Yes.
Okay. And you realize that that presents a conflict under the statute, but that is a conflict that you can waive. And do you wish to at this time waive that conflict and have me continue representing you in both these charges?
Yes.
Okay. No further questions, Judge.
All right, any issues or questions from the state?
Judge, just the fact that as Mr. Manning relayed to the court, I brought this to his attention. I believe the state would likely have a conflict as well. But at this time, we would waive that conflict and allow Mr. Manning to continue to represent Mr. DeCappa on his motion to revoke case. And obviously, I don't believe there's any conflict with him representing him on the new case.
Thank you, Mr. White. All right, that is noted for the record. Court finds that Mr. DeCappa has waived any potential conflict of interest with regards to the representation of Jonathan
Judge, that's all. May he be excused.
Manning. Thank you. We'll see you back on June 5th. Who do you like next?
Mr. David Simpson.
David Keith Simpson, CR 23-75. Show that Mr. Simpson is set for arraignment today on assault of a family or household member with previous convictions, third-degree felony.
Judge, that's actually been enhanced, I believe, due to a prior conviction. He is, I show he's listed at a second-degree felony. And gone over the indictment with him. He understands the charge. His name is spelled correctly, and this time we're pleading not guilty to that.
All right, the court will find that Mr. Simpson has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and the court will set this matter for pretrial hearing. Do you want that June 15th date, Mr. Manning, or do you need more time?
No, Judge, that would be great. As a matter of fact, if there's a date sooner than June 15th, we have a plea agreement that I've discussed with Mr. Simpson. He has some additional questions regarding parole that I'm going to speak to him about tomorrow when I come visit. So if there's any dates sooner than June 15th, if we can get him in, I think we'll be able to get his case resolved.
I've got May 30th. That's my evidentiary docket, or I've got June 1st.
Judge, is the May 30th Tuesday or Thursday?
It's Tuesday. This
Judge,
time.
if we can do June 1st.
All right. Court will set Mr. Simpson for pretrial and plea on June 1st.
Yeah, tomorrow. Judge, next I have Mr. Joshua Prater.
Mr. Prater, come forward, sir.
Good morning.
All right. This is cause number CR 19-244, motion to revoke. Joshua Scott Prater. Go ahead, Mr. Manning.
Judge, and I'm embarrassed to say this, but I was unaware that he was set today, as the docket that I have had Miss Ann Thompson still listed on there as his attorney of record. I did actually meet with Mr. Prater on the 28th of April. We discussed his case, but as I did not have an opportunity to discuss that with the state in preparation for today's docket, I request that we reset him for the June 1st docket to give me an opportunity to see if we can get things squared away with Mr.
All right, court will set Mr. Prater for June 1st for additional hearing on his motion to revoke. All right, Mr. Manning.
Judge, the last one I have is Miss Blair. We had an agreement reached yesterday. However, when I spoke to Miss Blair, she had some questions and concerns that I have not been able to address at this point in time. If I could have just a couple of minutes, I would like to go over that with her and see if we can continue with the agreement today, or if we need to reset that for a contested motion.
Absolutely. Go ahead, sir.
Thank you, Judge.
Yes, sir. Thank you, Fabio.
Ready, Mr. Manning?
Yes, Judge.
All right. we gonna do a plea today, or is there another announcement?
Judge, we will be going forward with the plea today on the revocation. Judge, I did have one question that came up in our discussions. I don't know if this changes the deal for the state. It's not something we previously negotiated, but Miss Blair would not like to plead to count 7. She had registered for the cognitive behavioral course. I explained to her that even though she may have registered, it may have been outside that 90 days, which is why that might be a violation. But she felt a bit unfair that that was alleged against her, even though she had completed that. So she would like to not plead true to that. But everything else she will be pleading true to.
State's comfortable with abandoning that count.
All right, somebody before we begin, Mr. Manning, what are the terms of verification?
Judge, this is going to be proceeding on a theft of property, $2,500 or less, with 2 or more previous convictions. The date of original supervision was August 9th, 2022. Date of offense was July 9th of 2021. That was enhanced to a 3rd-degree felony as a repeat felony offender. Upon a plea of true, the original terms were 4 years, TDC, probated for 8 years, and a fine of $1,000. Upon a plea of true, states agreed to recommend that punishment be assessed at 3 years, TDCJ. That sentence run concurrently with any and all other sentences. She has a remaining financial balance of $1,000 in fines, $290 in court cost, $135 reimbursement, as well as restitution in the amount of $1,090.58. Additionally, Judge, she has 205 days credit. And the count that the state abandoning is going to be count 7, which is condition B.
So that's condition B.
That's correct. B is a Victor.
B is a Victor. Okay. And what I'm gonna do is say, I'm sorry, what I'm gonna do state is I'm just gonna white out condition B, so we don't have to reprint that. All right,
State's perfectly comfortable with that, Your Honor.
All right, Ms. Blair, if you'll raise your right hand, ma'am, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Go ahead. All right, Ms. Blair, you heard Mr. Manning read the plea agreement that you've reached for the state. Is that correct?
Yes, sir.
And that's your understanding, and that's what you're asking the court to approve today.
Yes, sir.
You've read over the state's motion to revoke, which was filed on March 9th of 2023. Is that correct?
Yes, sir.
Mr. Manning, does your client waive the formal reading of the state's motion to revoke?
She does, Judge.
All right, now having read that motion and waived the reading of that motion, Ms. Blair, let me ask you, how do you plead to counts 1, 2, 3, 4, 5, and 6? Are those counts true or not true?
I was in rehab. I'm true.
They're true? Okay. And Ms. Blair, has anyone threatened you, forced you, or pressured you to plead true to counts 1 through 6?
No.
Court will accept the defendant's pleas of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection to a waiver of rights and plea of true.
All right. So Ms. Blair made a statement that she was in rehab. I asked her if those violations are true or not true. Is she alleging a defense to those, Mr. Manning, or is she making a comment? Can you clarify for me?
Judge, she is alleging a partial defense to the violations. However, upon my discussion with the state, they felt like there were still other violations that they could prove, and that they did offer her a reduced sentence from the max, which she was capped at 4 down to 3. And while Ms. Blair feels it unfair that she's not having a chance to continue on probation, and she feels like that being in rehab is a good thing, the state was unwilling to proceed any further in their negotiations.
So the counts that she's pled true today are counts 1 through 6. Is she alleging a defense of inability to comply with those conditions due to being in a rehab?
Judge, partially, yes, but that doesn't negate each and every section of those counts. She was not in the rehab for the totality of that time. And so as I discussed with her, as I discussed with the prosecutor, they're still able to proceed with violations in each of those counts that was outside the scope of time that we can show a partial defense.
All right, thank you, Mr. Manning. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Besides Ms. Blair's statement that she was trying to get help, she didn't try to violate her conditions intentionally. She was trying to do what's best for her family and for herself. We talked about she just kind of went about it the wrong way, and because of that, she understands why she's here.
All that true, Ms. Blair?
Yes.
All right, then, based on the evidence presented to the court today, the court finds that Ms. Ashley Blair was placed on, that she appeared before the court on August 9th, 2022. She was convicted of the offense of theft of property less than $2,500 with 2 or more previous convictions. That matter was enhanced to a 3rd-degree felony, that her case was resolved by way of plea agreement, wherein she was assessed a sentence of 4 years confinement in the Texas Department of Criminal Justice. The court suspended the sentence on that day and placed her on community supervision for a period of 8 years. It was during that period of community supervision that Ms. Blair violated the terms and conditions of her community supervision. Based on her pleas of true and the evidence submitted, the court finds that she violated her conditions of community supervision by finding counts 1, 2, 3, 4, 5, and 6 to be true. Due to those violations, the court follows the plea agreement. In this matter, the court hereby revokes her community supervision, assesses her punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders her to pay orders her to pay her financial balances previously imposed. The court finds that count 7 has been abandoned, and the court awards Ms. Blair 205 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Blair, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with Deputy McLeish. She's going to take your finger. Does that complete all your cases today, Mr. May?
I believe it does, Judge. May I be excused?
Yes, sir. As long, Thursdays are long days for you, aren't they?
Yeah, I get a break the rest of the week.
Hey, but it's Friday Eve, so there's always that, right, for you?
I got my jail visits on Friday morning, so I'm just kind of, I'm ramping my week up. This is my Monday and tomorrow's my Tuesday.
But we need to get you a cot. We'll just put you there. We'll get you a cot in the back of the jail there. Knock out work, burn the midnight oil and get that done.
It's tempting. Judge, have a good day.
Thanks. Have a good one. All right. Thank you, Ms. Heisel. Thank you, Mr. Woodblack. I think that concludes our criminal docket today. If nothing else, then we're going to be adjourned. Thank you, Deputy McLeish.
Thank you, Your Honor.